No, I don't mind.
All right.
Okay, so how many of you have run across the most form in the course of either your volunteering here or whatever? A
Definitely.
bunch of you? Yeah, it looks like a bunch. And does anybody here have a most form themselves? And I can't see everybody. Is that a no from everybody? Becky, you're gonna have to help me. Thank you, thank you, thank you. I am overjoyed that nobody has one, because none of you, I suspect, are appropriate to it. So what I'm going to do is just run through this. I think Becky has sent you a copy of the most form so that you could see it. And let's see if I can do this. Okay. We've already asked those questions, and I'm not going to ask you if you've shared your wishes. I certainly hope that this group is the choir in terms of sharing your wishes with other people. So the MOST is an acronym for Medical Orders of Scope of Care. This is a state-based form that was started in Colorado in 2007, and the last major revision was in 2015. The whole initiative started in Oregon, the place where a lot of end-of-life stuff starts, in 1991. And it is part of what's called the pulsed paradigm. But every state, and every state has some form of this at this point, has their own acronym for it. But your most form, what we have here, will be honored in other states by most people. I can't imagine that it won't be. But there is a national organization that certifies, and most of them run about the same. There's a few little curveballs in different states. And the whole purpose of the most form is near the end of life to take the wishes that you may think you have at a time when that's abstract. And in that last 6 to 12 months of life, or when you're very frail, convert those into orders that are need to be honored, are signed by a physician or a provider for the scope of care based on your current state of health. So it's not hypothetical. And because of that, it's a conversation that people have with their doctors. A lot of your hospice patients will certainly have this, and your PACE patients. The acronym, or the shorthand version and way to think of this, is that they're portable medical orders. And they're most helpful for emergency personnel to know what kind of specific treatments you might want or might not want during an emergency. Okay. So this translates wishes that were probably made in the abstract that exist on advanced directives, which are not legally binding for the most part, and translates them into actual orders that are to be honored. To be honored if you've got a copy, to be honored by EMS if you, whenever they find it, and to be honored in the ER. They're designed to improve quality of care. People realized, wait a minute, it's not so much about CPR as what happens in that gray zone when you have an emergency that isn't a cardiac arrest. And it allows you to avoid or affirm treatments that a person may wish near the end of life. And just as a reminder, people who are in hospice are not required to have a DNR. So the CPR part of this can go either way. And about 10% of people in hospice actually want CPR attempts. So it's intended for elderly, chronically, seriously ill people who have frequent contact with healthcare providers. Now, there is a problem with the most form and the ones that exist in the other states, which is they're misused by providers. I have several friends who were handed their most form when they became 65 and went to their doc for their 65 Alive appointment and were told, here, fill out this form and bring it back. That's not what it's for. And so one of my missions in life has been to try to teach docs that that's not an appropriate use for it. Docs have been told, oh, you need to do advanced directives with your patients, and here's the quick and dirty way of doing it, even if it's wrong. So it's filled out with the current health conditions in mind. So I live at Fraser Meadows Retirement Home right now. And when I came in a few years ago, I don't know what I'm going to die of. It could happen tomorrow, yes, but I don't have a terminal condition. I got handed one on admission, and it's not uncommon for that to happen, even if you're going into independent living. That's wrong. So I'm still working on it 4 years later, but we're making progress so that no longer happens. So this is the form. Whoops. This is the form. You got a copy of it. And I just want to point out a few things to you. A lot of this is technical, and you're not going to be filling these out with people. Although I think Becky's very reasonable reason for wanting me to talk about this is because you will run across them, and sometimes people will ask questions. You need an ID on the person, and in addition to the sticker that you might have from the admission of the patient, if they're inpatient, you need a few identifying things. And whoops, and then you need a CPR. The part A is, do you want CPR attempts? Yes or no? And as I said, even if you're in hospice, you are allowed to say, yes, I want attempts at CPR. And about 10% of people in hospice do by record. Can everybody see that? On my screen, I've got you guys blocking the screen. Is it doing okay for you guys?
Good.
And we
Okay.
can see it.
Okay, cool. This is the crux of the purpose of the MOST form, or the pulse paradigm forms, which is to go beyond, if you're dead, do you want to stay dead, to this choice of the level of treatments that you want, not the level of care, but the level of treatments. It took me a whole lot of years before my colleagues in ethics bopped me over the head enough to know that the difference is what treatments you want. Everybody gets comfort measures. But the question is, if you have an emergency and the 911 is called, or if your patient does, do they want a full court press, i.e. intubation, going to the ICU, defibrillation, whatever is needed? Do they want comfort-focused treatment with a primary goal of maximizing the comfort, or something in between? It'd be okay to go into the hospital. It'd be okay to have antibiotics for this pneumonia, that kind of thing. But I wouldn't want to go to the ICU if I don't have to, and I don't want to have a breathing machine. So that's sort of the three levels that exist. Now, I have this is the selective treatment particularly is very nuanced and very hard to sort out. And I find that the whole form is best for the pre-hospital people and the first 5 minutes that you're in the ER. After that, you have to sit down with patients and figure out what they want in this particular situation. And my example is my mother-in-law, who was clearly in comfort-focused treatment after a big stroke, and she fell down in her assisted living situation, broke 5 ribs, put 1.5 liters of blood into her left chest, so the ambulance was called. Now, number one, even though you're in comfort-focused treatment, oftentimes if you're in a facility, and you see people in a facility or at home, if the family can't take care of them, or if the nursing staff can't take care of them, calling 911 is appropriate and taking them to the hospital. Now, you guys are going to have to correct me if I'm wrong, but I don't think you get bounced out of hospice for going to the ER. Is that true? People agree with me on that?
if you're admitted, then you need to revoke,
That's
right?
that's
But
the key is, and I have to train my emergency medicine colleagues on this all the time, which is that before people get admitted, you have to call the hospice because you need to get an okay that no, we cannot take care of this person ourselves. And yes, we agree they need to go into the hospital. For my mother-in-law, we ended up with comfort focused treatment, having her in the hospital for 5 days, draining the blood out of her chest for comfort. And that was appropriate. And it was okayed by hospice because they couldn't do that. And so there are nuances to this. The first 5 minutes, I usually say, and it's probably 10 or 15, you stabilize people out using this as a guide. But after that, it requires the conversation. It's a different conversation than the ones you're usually having with your patients, but and your clients. But conversations are required for the nuance. And I actually think that the emergency department, I'm a little biased because I'm an emergency medicine doc by background, is really oftentimes the best place to be the triage point for deciding, oh, okay, now that you're here, let's see, your goal is that. I think we can do that by taking you back or putting you in inpatient hospice for a couple of days, or I think we ought to admit to the floor or ICU, that kind of thing. So that's sort of my take from the ER perspective. And then there is a part that talks about artificial hydration and nutrition. I don't think it's particularly useful for you guys. There are lots of nuances. And again, it really requires a conversation. But a lot of people will say, I don't want to have a feeding tube, either long-term or short-term. And then the most form gets signed. It is important to remember that if the patient themselves or the client that you have doesn't have decisional capacity, this can be signed by their legal authority. So hopefully that's a person with a medical durable power of attorney or somebody else who's a legal guardian. And then it has to be signed by either the advanced practice nurse, a PA, or the physician in order to be valid. And it should be revisited. When we get ethics consults, when somebody has a most form that's 5 years old, and we're looking at them, and we're looking at it, and we're saying, you know what, we're in a different place now. This is not really something that is relevant to the current situation. Let's see, I think. Okay, I guess that's the end of what I have to say. So why don't you guys ask me some questions here? Unmute yourself.
Hi, Jean. It's Jessica. I have a question, and this is a real life question. It just came up a couple days ago. If you have a most form signed with one physician at a facility, let's say Mount Evans, does it expire or does it go like null and void if you are no longer on service with that same facility?
No,
No,
that goes with the patient.
Goes with the patient.
No, with the person, it's their property. And in fact, it should be someplace that's obvious, like on your refrigerator, if you have one. And you should send copies to everybody that you know. They can be white copies. They don't have to be, the Vulcan green that is the original, etc. No, goes with the patient. Eben?
I think it's important to point out that in section A, that applies only if the person has no pulse and is not breathing.
Thank you for that.
If that's not the case, then you can still go to section B, where the person has a pulse and or is breathing.
Good point.
And also note that if yes is chosen for section A, you have to select full treatment.
So yeah, if you want to have CPR attempts, CPR does include defibrillation, intubation, and all the other stuff. So the one permutation that you can't have is no CPR or yes CPR, but comfort care. kind of thing.
And
It
there's
is-
just one more comment
Go
that I'd
ahead.
like to make, and that is sometimes there's some patients who have conditions like somebody who had one kidney and polycystic kidney disease. And of course, I didn't, know enough about their situation to know how close they are to renal failure and whatnot. And they know they don't want to worry about dialysis or a renal transplant, and they're wondering whether or not a most form is appropriate. You try to, I think, you try to advise them about what a most form is basically for. And if they have any questions, they have to get a physician, and preferably their primary care physician who knows them well, to sign it anyway. So that's a great thing to arrange to discuss with the physician.
Right, and you'll notice there is a sort of a blank line at the bottom of the A, B, and C, or the three parts of Part B that allow you to do a little of that nuance about dialysis and stuff. But to me, that's going to be a conversation that happens when they roll into the ER and their potassium is sky high. And the question is, do you want us to try dialyzing you a couple times, see if things get better, that kind of stuff. Now, your hospice patients will usually be saying they don't want CPR. And in fact, there's lots of people in their 80s and 90s who don't have a terminal condition who say, I don't want CPR, but yeah, if I need to go to the hospital for pneumonia, or if I have a cellulitis or a bladder infection or kidney infection, I wouldn't mind a go at the hospital. So there are a lot of people who say no CPR, but want more than just comfort-based care. So that's an important point too. Key to this is the stuff that you're doing, actually, not this stuff. It is important for you to know about it because you're the one, because you'll run across it, and because this does codify for your hospice patients what will happen if 911 gets called. And it's okay for 911 to get called. I find people who get all in a tither if, 911 got called, but they were for comfort care. In fact, I've had ambulance folks say, I don't know why we're here at Fraser because this person is a DNR. Well, give me a friggin' break. That doesn't mean don't care. So yeah, we had a hospice patient a couple years ago that happened to. And she heard the two paramedics talking behind her saying, I'm not sure why we're here. Yeah, I know, Evan. Very sad. So you're the guys who know and can empower people to understand that there are nuances and there are things they can't possibly predict, and that we change our wishes. That's Richard's going to be talking to you now, but that's my biggest challenge. And I think from what you said in the intro, Richard, that may be yours, is that there are nuances to this and there are changes. We change over time. And so there are some ways in which written advance directives block our understanding of what to do in the moment. So other questions for me, and then I'm gonna bequeath you to Richard here.
I just
I-
wonder if you have a phrase or a tactful way to say, if we're doing a presentation, especially when we get invited to do presentations at independent livings or facilities, that might have asked their residents to fill out a most form and they say, well, I had to fill this out. What's a tactful way to respect the invitation we received and also provide correct information?
Oh, Becky, that's a really, really hard question. Number one, by law, institutions, including nursing homes and hospice, et cetera, cannot require you to fill in a most form. My usual thing to say to people is, if you don't have the arc of the end of your life kind of situation, you should fill out a CPR directive, which you're welcome to do at any point, and then talk to your family, get your MDPOA and talk about your values, because that's the way that whatever pickle you get into, the people who love you can ferret out what would be most in alignment with what you want.
Can you speak for a moment about the CPR directive? Should I be passing those out at presentations too? Do people post those
I don't
like they
think it's
do
a
on
bad
most
idea.
form?
Some people are really passionate about not wanting CPR attempts. I'm not as passionate as some other people about it. I don't think it works very well or most of the time. And so I don't worry about it quite as much, but that is certainly the alternative if you don't want to do a most form. Or you can draw through, or the most form you can say yes CPR or no CPR, and you can say full court press if somebody forces you to, but I don't think that's the purpose of it. And it's very frustrating to me that physicians and nurse practitioners and PAs are not using it properly. But most of your folks will have a most form, and it will be appropriate because they're in that last 6 to 12 months of life. So that does help because they sort of know the trajectory of their exit. And they want desperately that their wishes be honored when 911 gets called, which will happen. Jessica, quick question, and
I have one.
I got to run. I'm sorry, guys. I have an actually conversation project presentation to a group I don't know about that is upstairs here, and I have to run. But I'm glad to come back and thank you so much for all the amazing work you do. This is the important stuff. Yours is the important stuff, not the most form. So bravo to you guys.
Thank you so much, Jean.
Okay.
If you have a question for Jean, email me, beckyparr@truecare.org. She's very responsive, and I will make sure that you get your question answered by Jean. Because I still have a couple in here. I was at a presentation sometime this last year, and I think that we've all probably encountered people who are aging independently, and they are concerned if they can't identify a healthcare agent, how do they get their wishes shared? And the advice that somebody gave was, well, just make sure you have a most form, put up your most form. But the person who was doing that was a very healthy person. So, that advice was from someone who is solo agent and kind of gave her the peace of mind to know at least there's a doctor's order, at least there's something there. But hearing from Jean, I don't think Jean would say that is the best thing to do. So I'm kind of curious, and we have a lot of smart people here, what you would say to somebody who's independent aging and doesn't have someone they identify as a trusted person that they would want to be a healthcare agent, how they might share their wishes around CPR. Does anyone have any advice?
Becky, this is Jeff. I think one of the things that is available to all of us is to write a narrative, whether short or long, where you have thought through different circumstances and your response based on your own values and what meaning you have, and how you would like to be both perceived but also cared for. And that addendum, to a living will or to a formal advanced care plan carries a lot of weight because it's obvious that you thought it through, and if it is available, and that's the key, is to have those documents be fully available so that where you live, who you relate to, understands and knows about the documents, is a good avenue.
Thank you. Kim, were you thinking about raising your hand there?
I do.
Yes. Kim, we did introductions earlier. So Kim is also on the advisory board and does amazing work around end of life. And what's the name of your organization again, Kim? Out of the box?
Dying. Practically dying.
Practically dying.
Yeah. Yeah. So I have a couple things I wanted to add. The CPR directive, I think it's always helpful with my clients. I always ask them to write something about why they're making that decision as part of the narrative. And we had one woman who said, I had surgery and most of my sternum isn't there. So for God's sake, don't crack my chest. So I think it really helps when people are, especially the ones who are trying to talk you out of it, to know why what's going on. And particularly with the solo agers, you know, we always have on these forms, leave a copy with your primary doc, but if you're in a hospital, you may not see your primary doc. So if you are already if you're already a patient at an established hospital, you can go in proactively to that record. I think that's really an important place to make sure that things are as in the hospital record, even if you don't have a primary doc. So a lot of people do that thinking, you know, I mean, it's a crapshoot because you could be in Florida, but basically, what is the hospital that you mostly get service from? So it's important to keep that up, not just put an advanced directive in it. And then
You
the
can
last
put your
thing,
own advanced directive in the hospital record.
yeah, they want to have your advanced directives in there, but if you have something like a CPR directive, think of that as important as leaving it with your primary doc, you know, who we hope is the one that's had those conversations. And just incidentally, I've run into organizations that have sweated because they couldn't find Vulcan green. And any green that's noticeable will work. The reason they chose Vulcan green when this first was passed, was because it is the green. These were printers who helped work with this. It is the green that is the most likely to stand up to repeated copying and still be legible. So there's no legal requirement. We just want it to pop and be available. You know, that's all, just so you know, because people have been not doing it because of that.
Does the CPR directive have to be signed by a physician?
My understanding is legally no, but again, when you're working on the street, I think what's the most important is to think about what's really going to work rather than what you can hold up. Yes, you know, there's the cocktail napkin story, but in the broader sense, what are you likely to have honored? You know, so if you're in an emergency situation, they might dither over whether the napkin is worth it or not, or the tattoos. You've also heard the stories of the tattoos. You know, there've been at least 2 people who had them tattooed on, and as far as I know, neither one of them got to the point where they went into ethics consults and things, but neither one of them was that the deciding factor, including a great nurse from BCH who said she had tattooed over her heart, "Press here for lawsuit," which I thought was really good. But again, never had to come up. So somebody else might have a different answer to that, but I'm very inclined, after I've seen the variety of ways that medical professionals know or don't know how to respond, to just say, do what is going to get you the most purchase in the broadest way. I wouldn't put it on a napkin and hope that it would work.
Since we're talking about the CPR directive, I'd like to point out that it says, I hereby direct emergency medical services personnel, healthcare providers, and any other person to withhold cardiopulmonary resuscitation in the event that the patient's heart or breathing stops or malfunctions.
Mm-hmm.
So that would mean that if I choked on a hot dog, I'm refusing to be treated for that.
Wow.
I mean, that's the way I read it. Maybe somebody who knows more about it can correct me. And, you know, if that's the case, would it be possible for a person to alter that? And, you know, so that it's, if my heart and breathing stops, or, you know, something like that. You know, if you just are concerned about not having a sternum and not wanting to get your ribs broken, but you would be happy for somebody to give you the Heimlich and get the hot dog out of your airway, you know, you might not want to sign it.
Yeah, that makes sense.
And Kim, I think you have been one who's often recommended award and sign or something like that, but there are several ways that you can make it easy for care providers to discover what your wishes are. There are bracelets you can wear. that give information about a website you can go to where you have your wishes on file at the website. I'm sorry I can't bring those resources up right now, but there are some options.
Oh, yeah. And I'd like to thank you, Evan, for saying that, because again, technically you can go buy yourself a bracelet and put no CPR on it. It's more, what are they going to pay attention to? And the reason award and sign was a big deal at one time, it was the first place that offered the bracelets, and the bracelets actually have on them your name, your description. I mean, more the information that's on the most, so that at least the first generation of responders that I worked with wanted to make clear that it was the right person. So they followed the most format. They also were like $30. And the other, and this was a while ago, the other place that was offering it, which was like MedAlert, you had to subscribe. You had to be a member. And so that was prohibitive for a lot of people. So yeah, I'm sure by now there are other places. They just were saying to me, how do I know that they didn't get this made at Target or something? So what Award and Sign was doing was trying to make it look as much like a diabetes bracelet or something that had weight. That's what they were doing. I haven't talked to them in a couple of years, so I don't know what's going on now.
I think the other resource is Road ID, isn't it?
Yeah.
That does give you, a place to have identifying information and numbers of people to call.
Road ID is very comprehensive and it's incredibly cool. The problem I have with the ones where you get access to a cloud is they don't want to spend a lot of time trying to find another resource. They want something there
Right.
for 4 seconds.
Right. At least it's something.
Yeah. Oh, I think everybody should have Road ID just because it's so cool.
And by the way, I think, whenever we get somebody to fill out an MDPOA form, attached to the MDPOA form should be contact information for the healthcare agent and any healthcare agent alternative.
Mm-hmm. I agree.
Becky, this is Jeff. I kind of missed the actual answer, but the Colorado Most form must be signed by a licensed clinician, whether it's a physician's assistant, an advanced practice nurse, or a physician. There's not an alternative to that.
Mm-mm.
Exactly.
Right. The question I think was about the CPR directive. Does it need to be signed by somebody? But this talk about healthcare agents, I think, lends itself nicely to something Richard brought up not too long ago in a meeting I had with him. And also, I want to honor Richard's time and expertise and have him. We're going to pivot a little bit, but if you have any other questions about most forms, or just as kind of this ongoing conversation, maybe I need to sit down with a few of you. The most frequent questions I get are from people who are solo aging, and I would love more material or even a more robust presentation to be able to really try to meet that need in our community for people who are aging independently healthy. But one person even said, I like being isolated. Like, I'm not going to go out and make more friends. So if it's, how do we help them if it's, we have people who have social, emotional, or mental health disabilities. How do we make sure that we give them agency as they age? And so if anyone has resources or ideas around something I can include in the material that we use in presentations to address those needs, that would be wonderful. I'd love to have coffee with you and figure out some ways to provide that. So now I'm going to turn it over to Richard to talk to us a little bit about ACP law as we present and also coach. It's just good for us to know what the law actually is in case we get questions, and also to make sure we're not acting outside of our roles, which can be easy to do sometimes when, I'm learning a lot constantly, but there are some things that only lawyers should do or only physicians should do. And I just want to make sure we all kind of know where those boundaries are. So Richard, thank you for being here.
Okay, am I a host? Can I share my screen? Can you make me one?
I thought I made you a host, but let me double check.
Okay, I might be.
There you go. You should be able to share your screen.
Okay. So, yeah, so what I'm going to talk about are legal issues that relate to advanced care planning and advanced directives. And I did a program a couple of weeks ago with Becky, who is a group down there in the Golden area that is starting a new conversation project chapter. And their concern was about where's the line about unauthorized practice of law. And there were concerns about that. And so there should be. So I think I want to talk about that first, so you all as coaches know what you can talk about, what you can't talk about, what you should talk about, and probably shouldn't. So really, when talking about legal issues, we should go to the source. So let me go to my share screen here and see where I can find what I'm looking for.
Is it not working? We're not seeing it.
Yeah, no, I'm not finding it, unfortunately. Let me see.
Now, one of the things I remember Richard saying, just to put out in the beginning, is that nobody's really ever been sued over this kind of thing in record. So I don't want anyone to stop being a volunteer or coach because they're worried about getting sued.
You're not, there aren't police. Anyway, this is as you can see in the address bar, this is the Colorado Supreme Court website, and they're the ones that are responsible for dealing with complaints against attorneys and regulating attorneys. We're very, very closely regulated, as we should be, but also dealing with unauthorized practice of law issues. So if we come down here where it says complaints, discipline, and unauthorized practice of law, and then understanding UPL, unauthorized practice of law, you go to a PDF document and that explains the issues. And so I'm just showing you this so you can follow it if you want to learn more about it. But the first question is, what is the practice of law? And the answer here is the Colorado Supreme Court has defined the practice of law as, quote, acting in a representative capacity in protecting, enforcing, or defending the legal rights and duties of another, and in counseling, advising, and assisting another in connection with these rights and duties. The court's words make clear that providing legal advice to another person constitutes the practice of law, as does, and this is where we might get in trouble sometimes, as does the selection and drafting of legal documents for use by another person. A non-lawyer's exercise of legal discretion on behalf of another's legal interest is prohibited because of potential harm to the public. Now, there's nothing I think we as coaches can say that is going to harm the public with regard to medical powers of attorneys and living wills. I think sometimes the biggest danger is not telling them things that are available to them and options that non-practitioners may not know about. But just to continue, thus, a non-lawyer generally cannot provide legal advice to another. And number 2 and 3 are the big ones in our situation: select legal documents on behalf of another, or 3, draft legal documents on behalf of another. So medical powers of attorney and living wills are legal documents. So to the extent that you're selecting the document for them, and I'll get into what I mean by that, or drafting anything, that is the practice of law. Now, as Becky said, don't get, freaked out or anything like that. There's not like there's UPL police listening at the door. And all the time people will say, oh, I just downloaded this form from the internet, Mom, you should fill it out. That they are selecting a document. That is the practice of law. But on the continuum, that's not a big deal, and that's prosecuted. So not to, worry anybody about that. The things this Colorado Supreme Court are concerned about are people that are drafting pleadings or going to court for someone or writing complex contracts or estate plans. But technically, selecting legal documents or drafting documents is the practice of law. And I can tell you, the real estate industry got into a little trouble along similar lines. You know, real estate agents were routinely preparing real estate contracts. And they're all fill-in-the-blank contracts, but at a point, they said, no, you can't do that. And they proposed new rules to allow agents to do some limited type of work in that regard. But there was a time they got into trouble doing that. So I don't know of any cases where people got in trouble in this field, but that's just sort of an analogous situation. So let me just show some examples how this might work. So you all recognize this. This is the Conversation Project in Boulder website. And they have under resources, and it's a great website. So if we go to resources, and this probably is going to have to give it a second. And then once you go, the main thing I'm trying to show here is even on the Conversation Project in Boulder website, there are 4 different medical powers of attorney on the website that people could choose from. There's here, I have one here. This is one here that I think you're all probably familiar with. I don't know if you can see that, but I'll pull it up once my website. So there it is. So, and then if you go to documents, and this might, you can come, this is this one. Here's the Colorado Medical Durable Power of Attorney form. So if you click on that, you see this form, which is a pretty standard form. There's nothing wrong with this form. By showing this by having it on the website is not a problem. There's this form here, the power of attorney card. This is just this little business card size thing that you can put in your wallet. And just to show you, it's so easy to make a legally effective, legally binding medical power of attorney. All you have to do is sign it. Legally, to be effective, it doesn't even have to be witnessed or notarized. So they're very easy to create. As I said before, the problem is, how is the agent supposed to know what to do? And that's what really the main work of the Conversation Project is getting those wishes out there. Here's a form from the U.S. Department of Veteran Affairs. So they put out a 80-page booklet. And if we scroll down here, I think it's page 51, you've got a VA Advanced Directive, Durable Power of Attorney for Healthcare and Living Will. This is a 7-page document. So you see, what happens if one of your clients, will say, someone that you're coaching, says, which form should I use? I'm a veteran. Should I use the veteran form? Should I use, this form? Should I just use the business card size one? So I think that's what is meant by, if you're selecting the form and telling someone which form they should use, that is potentially practice of law. It may seem like a little thing, and again, I don't think anyone's going to come knocking down your door, but that's what the rules are. There are some parts of these here. I'll show one more that's on here is from the Colorado Hospital Association. So they have a 21-page booklet that also has a medical power of attorney form and a living will and all kinds of advanced directives. So and you can go on the internet and there are dozens, if not hundreds, of forms that have slightly different provisions. They're all a little bit different. How do you know which form to use? And you're probably not supposed to select the form for someone to use. Certainly what you're not supposed to do, like in this form, there's a place here that says, state here any desires concerning life-sustaining procedures, treatment, general care, and services, including any special provisions or limitations. So you've now coached your person for an hour. They've told you what their real concerns are. Say the person that says, I don't want CPR because of the sternum operation. Should you sit there and say, well, let me help you draft a paragraph that explains why you want this or why you don't want that? And I think that falls under your drafting a legal document. So I think what the Conversation Project's main mission is a powerful one that I agree with so much, is helping people identify and articulate to themselves what their wishes are. And then how do we communicate those to the people that, you know, love and care about us, and our, you know, the medical people and the people concerned about our care. That's what we should be focused on. So not to scare anyone, but you know, you wanted to talk about what the law is. And this is, I think, an issue that how far can we go? Now, for example, I think you would all agree that we as coaches or non-practitioners should just sit down and start drafting our own medical powers of attorney from scratch. You know, I think everyone would agree that, yeah, that's not okay. But even just doing little provisions could potentially run afoul of what the rules are. So that's my little talk just on unauthorized practice of law. And I want to pull up a few provisions in the law and show them to you of things I said before. The danger to the public, I don't think, comes from you telling someone which form to use or helping them draft something that they want, but it's not being able to tell them things that you may not know. And there are a lot of provisions that you could put in a medical power of attorney that you will not find in any pre-printed form. So I have drafted a few for my clients. So this has been a common thing that I see is I'll have clients come in and say, I have 3 kids and I want all 3 of them to be the agent under my power of attorney. And I think we all know what a disaster that would be. And what I think they're really saying is not that they want all 3 of them to have decision-making authority, but they want them all to communicate with one another and to maybe reach a consensus, or, you know, not to be left out. Sometimes clients will say, I want all 3 because I don't want anyone to think I love them more than the other, or that I trust them more than the other. So I drafted a provision that most clients like that says something like, you know, I believe it will be helpful for the agent under my medical power of attorney to consult regularly with the members of my immediate family regarding my diagnosis and prognosis and potential treatment. And I therefore direct the agent under my power of attorney to consult regularly with members of my immediate family, or my sister-in-law who's a doctor, or what, you know, what have you. And in addition to consulting with them, I want them all to try to reach a consensus where possible. So usually that satisfies clients, and it's much better, I think you'll see, than, oh, I want all 3 of my kids to be agents. So you choose one, but you give all of them the authority, you give the direction that they all need to consult with one another and try to reach a consensus. There's another provision that I like that I've been using a lot and putting into powers of attorney, and especially in aging solo situations. What if someone has maybe only 1 child? The question comes, well, what happens if something happens to them or they don't have anyone? You know, there are professional agents under medical powers of attorney. And I think, Kim, I just digress a second. Is that what you do?
The answer is no, 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 no.
Okay.
Want to.
Well, anyway,
You're right.
there are, just like there are professional fiduciaries that will be a professional trustee or pay bills. Colorado is, I haven't seen it, and I'm from Florida or came from Florida. You can actually hire a professional agent to act as the agent under your medical power of attorney. So there is a statute. Let me see if I could find it here. It is 15-14-711. So, okay. So if you want to look this up, the statutes, and all laws are from either statutes or case law. This is section 15, or well, actually title 15, article 14, section 711. And so I'm looking specifically at number 2, which I think is very powerful, that you could put in a medical power of attorney, but you'll never see it in a pre-printed form. It says a principal may designate 1 or more successor agents to act if an agent resigns, dies, becomes incapacitated, is not qualified to serve, or declines to serve. Okay, we all know that. That's just choosing a successor agent. But the principal may grant authority to designate 1 or more successor agents to an agent or another person designated by name, office, or function. So what this says is, if I just have 1 son and I'm concerned, but what happens if they can't do it? I have no one else. You can give that agent the authority to select the successor agent. So even though I don't know who the successor might be, my son, who's the agent, can select their successor. And who might they select? Well, I think in that case, it might be a professional agent. So a professional agent under medical power of attorney that can step in. So that seems to put some people that are aging solo or that don't have anybody to name as an agent or successor agent, the peace of mind of knowing, okay, well, if my son can't do it, then they can at least hire someone. And then comes the whole issue. Okay, now you're hiring a complete stranger to make medical decisions for you. How in the world are they supposed to know what to do? And the answer is by what the Conversation Project does and many other organizations, documenting what your wishes are under different scenarios. And the Conversation Project is, I think, the premier, the Cadillac organization, but there are others, like 5 Wishes, I think you've all heard of, and I think is on the Conversation Project website, has, sample instructions. The American Bar Association has a toolkit for advanced directives. And there's so many different types of questionnaires that are out there that you can fill out and create a file, which is what a good agent should do, is have a file that not only has what prescriptions you're taking, what conditions you have, but also paragraphs and letters of what your wishes are under different scenarios. So this is the kind of thing that I sometimes get concerned with. Not that we, non-practitioners as coaches would say something wrong, but may not know all of the different nuances and different options that are out there. So my suggestion is stick to what the Conversation Project does best, which is helping people identify and articulate their wishes, helping them have the conversation with their family, helping them create a file or documents that express what their wishes are, and not so much with, let me help you fill out these advanced directives. Say you need to have them for sure. They're very important. But again, choosing which document or giving them a document to fill out, drafting things for them is probably in the areas of things you probably shouldn't do. So here's another error that could happen sometimes with that's common. If you're saying, well, here's a form. There's some forms that combine the medical power of attorney and the living will into one. I think the Veterans Association, the VA had one like that, and I've seen a lot of those. So in Colorado, a medical power of attorney doesn't need to be witnessed or notarized to be legally effective. You just have to sign it. A living will, on the other hand, has to have 2 witnesses or a notary. So if you have them combined and say, oh, well, here's the medical power of attorney, I just have to sign it. Well, it's not going to work because those forms need to comply with both laws, the laws relating to medical powers of attorney and living wills. So there are some of the potential pitfalls, and there are many of them. So that's the reason why staying away from the drafting and the selecting of documents is probably not where the focus should be. Keeping in mind also, if you do it, no one's coming to arrest you, but we want to make sure that our clients, our people are getting all of the right information, not necessarily the wrong information, but getting the information that would be right for them in their particular situation. And they may not be in the standardized forms, but they may be allowed by law, but someone has to draft it. So I know, Becky, you had sent me an email and said, well, what do we do if the person we're coaching is of limited means, doesn't necessarily have the money to hire an attorney? Are there resources out there? And there are. So, and Becky, we could talk about this. I was thinking about it a little bit after I got your email. It's called MVL, Metro Volunteer Lawyers. They are a group of volunteer attorneys, and I have worked with them as well, because lawyers have to do a certain amount of pro bono work along with, continuing legal education. So that's one thing that they do, and they offer legal services to people that may not have a lot of resources. So it's MVL, Metro Volunteer Lawyers. It's run under the Denver Bar Association, and they have clinics that, in fact, here, let me, I guess I have to stop share this. And now I got to share again. Hold on. And so I looked up this old email that I got, Becky, and this is, I guess, for you, but for any of you. So up here, this is from 2021. So this is a couple of years ago, but they do this. But Metro Volunteer Lawyers is excited to expand upon the availability of our in-person clinics. Here, I'm coming to the fourth. Here, MVL's Power of Attorney program. This is a pro bono clinic that we conduct to help low-income seniors complete advanced planning documents. Specifically, we help applicants complete medical powers of attorney, a general, durable financial power of attorney, advanced healthcare directives like a living will, and a declaration of disposition of last remains. So they do these clinics from time to time. And Becky, if you got in touch with them, maybe you can do a partnering kind of thing. I know the other thing I was going to suggest, Becky, is you've got, on the resource page, you've got a list of legal professionals, and I'm on there, and there are some other legal professionals. I think you should tap in onto some of those attorneys and say, let's put on our own clinic. And so if you have clients that are, we have people that are coaching that want help in filling these out, I think it's probably better to reach out to some of those attorneys to volunteer some of their time rather than leaving it to, the volunteer coaches to maybe step into areas that they might not be as best suited for. And I think in return for having their name up on the sheet, I think you've got to reel them in a little bit and let them help some of our people fill out their forms, the right way and really address their issues more specifically, I think is probably the better practice. But that's just my view. So
No, that's a good idea.
but
Maybe you
I'm
could have
happy
a
to-
happy hour and I
I'm
can meet all the
happy-
lawyers.
I think that's great, having a happy hour with the attorneys that you've got listed there, with maybe a lot of the coaches and volunteers, and talking about putting together clinics every so often would be probably the best way to deal with helping our people fill out these forms.
You have a couple questions, Richard. Jill and Kim have had their hands up for
All
some
right, I'm
questions.
gonna stop sharing. Wait. Okay, fire away.
Jill. Go,
Okay.
Jill.
Two questions, Richard. One, I'm gonna misquote you, but I thought you said something like advanced directives are important. You should have them.
Yes.
What if my understanding was if say I've articulated my wishes very clearly to my MDPOA, then that's better than an advanced directive, because as Jean just said earlier, we're not going to know all the nuances. I don't know that I want to be off of a ventilator in 72 hours.
Well, to me, I'm defining advanced directive as, the legal documents like a medical power of attorney and a
Okay. Advanced care planning is what you're saying.
Well, advanced care planning is the plan that I think includes like the conversation project work. Advanced directives are the legal documents.
Okay.
In fact, from a really narrow sense, if you look at the statute, an advanced directive is really only a living will, but it's been expanded, and the more common use is when you say advanced directive, it's a medical power of attorney, a living will. It's, could be a most form. It could be what to do with my remains when I'm gone.
Okay.
The advance directive is just a form that I guess is giving direction in advance of when it's needed.
Okay.
So those are the legal documents. So you should have, what I'm trying to say is you should have a medical power of attorney, you should have a living will, should have your HIPAA form filled out, and probably, I think most importantly than the legal documents are the instructions so that the people know what to do. But it's not an either or, you do it all.
Okay. And then secondly, I guess I'm really focused on what you were saying about the legalities of selecting a form, that sort of thing. As a coach, I have never helped somebody fill something out. But I have always said, if you do nothing else, even if you don't have a will, determine who your agents are. Fill out.
Absolutely. What I'm just saying is don't give them which form to use. There are 50 forms out there on the internet. Which one are you going to tell them to use?
Well,
The
and
color-
didn't you say, Richard, that because I asked this question because we always give a folder full of forms that match kind of with the PowerPoint, and then if we just say something like, "This is one of many forms,"
I
you don't have
think
to
that's
use this form, but this is one of many forms.
Okay.
I think that's the best disclaimer, and I think you might want to put it on your website or in the material, because I think you normally give out, the
Yeah, I
little
always
card.
include it.
You always give out this one and the card. So which one do I use? What if I fill them out and they're different? So I think it's important to do is that you can give out all the forms in the world. They're all over the internet, but I don't think are able to say which ones to use and say, these are 2 forms. There are many different forms that are out there. Many different forms have slightly different provisions. I can't tell you which one to use, but these are all legally sufficient. It's not that this one isn't going to work, but they may not do all of the things that you want it to do. Like, for example, the couple of provisions that I just shared with you.
Okay.
So,
Got it. Thank you.
And that was part of my question, was those provisions you shared, would we as a coach be able to say, I've heard people suggest adding this kind of provision if it fits their situation, or is that?
well, it's getting close. I think the right answer is, if someone says, I want to name 3 people, are there other choices, rather than naming 3, because you're probably all going to say, that's probably not a good idea to name 3 agents. Well, what else can I do? The right answer is probably, speak with a professional that deals with these legal documents. And I understand it may be a very simple question that you know the answer to, but then it just leads to something else. Well, then how do I write that? Well, then, and you're going to end up going down a rabbit hole a little bit. So getting professional advice on the documents is usually the best answer. If there are people that are of limited means, I could work with you and talk to you about setting up clinics and really reeling in some of those attorneys that you're giving free advertising to, kind of, and saying, look, we want you to come in and come to a happy hour and learn about what we do. And I shouldn't be the only attorney in here. I deal with a lot of these issues, and all the other estate planning attorneys deal with the same issues. And and again, MVL is the organization that down in Denver that basically does that. So maybe you can work in conjunction with them as well. And also the Boulder Bar Association every so often does clinics. It's just pretty sporadic, but I can put you in touch with people there and say, we'd like to do a clinic. And I'm sure they would do that. They've done it in the past.
Kim, did you get your question answered? Kim?
No, I have a couple more. Am I on? Yeah, you can hear me. I have a couple things. And the first thing I want to say, Richard, is, and I do not mean this as a diss to your profession, but I'm probably going to do that and tell you, so much more, even sitting here, than a lot of the lawyers I've worked with. So I have a sort of a cynicism about that. And it fits in particularly. Anyway, I would hire you to teach all the other lawyers, is what I'm trying to say, because I've run into a lot of lawyers who.
Well, Kim, it's not, I'm no smarter than any other attorney. What I do that's different is the process that's different. I focus more on the instructions. Anybody can complete a medical power of attorney and a living will. They're not difficult documents to do, but that's not what's going to further,
Right.
and make sure someone's wishes are respected and
That's what I'm
understood.
saying. I'm not saying that they're not smart. I'm saying that jumping over into real understanding of end of life care, I've seen people who were just a little bit trained, but not very well trained. And so I drill them, because I still have people who showed me documents that were written as an estate plan in their living will document, which is that 210 or 2010 form that's in that blue book, the first one, is stuck in the middle of the document. It's not pulled out or treated as anything different than the will. And what I'm saying is, I think you're more exceptional than you know in terms of your knowledge about this field. I just do, based
All right.
on my experience.
Well, thank you for that.
So there's that. And so what I see often is exactly what you brought up is we're working on a form with somebody and we get to that section that says, here are my specific requests. We can't necessarily do that, but that's actually where they need the most help, is really drilling down on those things. And it's hard to find resources.
Here's one trick that I think you can do is sometimes I'll tell my clients, just fill out your conversation project starter kit or your workbook or any other documentation that you have expressing your wishes, and just write in that place, see attached, and staple your things to it.
Yes.
So, is that drafting? Yes, but that's
No.
another thing. Just see it, and it's really them writing their own thing. You're not drafting it. You're not writing it. You're just suggesting attach it to the living will, and that's one little trick. And you could just write see attached.
That is what I do with my clients, but what we've started doing, I'd say, and I'd love to talk to you about this sometime, this is probably over half of what I do with people, is that in the last 10 years, particularly what we found is what everybody has said. You don't know when you're in that room, whether that medical procedure, in fact, there's a great article was written about why these don't work. And the first thing is you don't have them and you can't find them. The second thing is that they don't really match what the doctor's seeing going on in the room. So they're like, hey, you said this a long time ago. It's one of the things that trips people up. So what more and more people have started doing is asking people to just write down their values. And then those are easier to interpret, or put them in a video. That's another thing, so that you actually see, hear, whatever. See the
So this is what I find is if I tell my clients, okay, write down your instructions and your healthcare wishes. And as coaches, you get a blank look. So having some kind of prompts, and that's why the starter kit is good, or having some sample instructions they can look at and then modify somewhat and then using that to craft their own letter. I mean, that's what we as coaches really should be doing. That's the coaching part of it, is helping people articulate and identify what their wishes are and get them down on paper, and then helping them actually have the verbal conversation with their family. And how do you do it? Because it's a tough conversation to have sometimes.
I'm so thankful for all your time. I'm realizing it's 6 o'clock, and I'm so thankful for the turnout we had, and Richard and Jean, and the interaction. I think that our next meeting is going to be focused on coaching. So we'll probably have a little bit more of this type of information shared, but just I hear from many people, presenters and coaches, that they would love to coach more. So I want to try to figure out how to be able to have that be more part of what we get to do. Real quick, I'll send you all an email. There was a couple other things I wanted to let you know about. We do have a couple presentations if you're still a volunteer that needs to do some observation, or a volunteer that wants to go out and have me observe. I know Libby's more than ready, so putting you on the spot. We're going to get to go to Balfour in March and April. I'm going to the center with Jeff, which I'm excited about, the center in Colfax, which is a community that serves LGBTQ plus and older adults there. So thank you for your time, and look for an email from me for what's coming up. And Richard, that was just really, really helpful. Really appreciate you. Have a good night, you all.
See you all later.
Thank you all so much.